Okay, hey y'all. Joining us today is a man who needs no introduction in Hawaii's criminal justice community, attorney Myles Briner. He's a seasoned litigator, a constitutional watchdog, and someone who's never been afraid to call out prosecutorial overreach when he sees it. Mr. Briner has decades of experience handling high stakes cases, and he's here to help us unpack the ethical and legal landmines here in the Gerhart Koenig case. So, first, I wanted to introduce Mr. Myles Briner. How's it going, buddy?
Doing great.
Right
Thanks for
on.
asking us to participate.
Very good. And then next, we have somebody who you might not know, but is sort of like a legal, like a rising legal star in Hawaii's legal scene. It's Mr. Andrew Strand. He's a former prosecutor turned criminal defense attorney at the law office of Myles Briner. He brings a very sharp intellect and strategic mind to everything that he touches. Um, in short, basically, I saw him in court one morning, and it looked like he was playing chess several steps ahead of everybody, the court included, while everybody was stuck playing checkers, going one step at a time. He does have what I would say is kind of like a beautiful mind. He's very quick, he's very smart, very intelligent, and he's a rising star here in Hawaii. So I'd like to introduce Mr. Andrew Strand.
Good morning, Nicholas, and thank you for your kind words.
Yeah, right on. So, the very first subject that we're going to address is probably the biggest case in Hawaii since the Mike Mitski case. We'll
Yeah.
talk about Gerhart Koenig, which is the case where the doctor from Maui was on a staycation here on Oahu and is accused of allegedly trying to push his wife off a cliff on the Pali Lookout hiking trail. What we're going to start with is the very beginning when he was charged, and then a bail of $5 million was set. And then later, via grand jury, no bail was set. So, first question to either of the two of you: is it unethical for the prosecutor's office to set a $5 million bail where somebody might be able to post it and then like a week later go to the grand jury where you don't have the defense counsel present, and then move to have no bail, and then theoretically that $5 million bail, you just bankrupted somebody because now they're just going to get picked up and put right back in custody? What are some of the details of the ethics of setting bail and then going to the grand jury and then taking it right away?
I'll defer to Andy on that. I mean, I have my opinion regarding the use of bail as a bludgeon. And any attorney, albeit a prosecutor or a defense attorney, knows full well that you increase the odds exponentially of a conviction if you keep someone locked up in prison. Hence the use of high bail or no bail, especially in high profile cases where the prosecutor's office reputation is on the table. So, but Andy's more recently from the prosecutor's office. He's gone before the grand jury. He knows the ins and outs. He knows how easily it can be manipulated when you don't have opposing counsel to say anything about setting a bail or the presentation of the evidence.
Yeah, so Mr. Strand, like, set the scene of what it's like and how easy it is at the grand jury to get whatever you want.
Well, if I could just take a short step back and address the judicial determination of probable cause underlying the initial arrest of Mr. Koenig. In this case, what the prosecutors did, I imagine, is they cut a complaint at the district court level. Now, the prosecutor is not the one setting bail, but they are recommending it to the court, the neutral district court magistrate, who ultimately is going to say yes or no to that $5 million ask. Meanwhile, and this is all about timing because there are very limited grand jury appearances in the First Circuit. So depending on which day of the week necessarily, you cut the complaint because there's 48 hours to charge or not, and then you go and beat your preliminary hearing with your grand jury proceeding. So in this case, a district court judge set the bail at $5 million. And in the meantime, the prosecution likely had no intention of ever proceeding with a preliminary hearing. Why? Because, like you just mentioned, it's easier to go before a grand jury, which is an ex parte proceeding, meaning it's just going to be the court, the prosecutor, well, not even the court, just the grand jurors. They're going to be the fact finders and the finders of the law. after the prosecutor spoon feeds them whatever facts they need to meet their elements to achieve their true bill in support of the indictment. So in this case, the $5 million that was initially set at the district court level never had a chance because they weren't going to go to prelim. Because why allow the defense their first bite at the apple, their first side, as Tommy Otake said in the bail motion, to tell their side of the story and to impeach the credibility of the witnesses through cross-examination when they can just take their evidence, give it to quorum of members from our community, a grand jury that's been impaneled for the year to hear evidence from the same prosecutors over and over again, who typically inure them to their side, make them partisans to their case, which they shouldn't. And it's frustrating because once they get that true bill, then we take the grand jurors out of the equation. And at the return hearing, when they address bail, now we just have the administrative judge trusting the prosecutor as an officer of the court, where they already have their position bolstered by the fact that a grand jury has returned a quote true bill in support of the indictment. And then it's just blind faith at that point. So in terms of any ethics, I'll leave that for Myles to address. But for a prosecutor to go before the administrative judge at a bail return post grand jury, knowing that bail has been set at $5 million, and I'm not sure, we don't have access to those transcripts. They may have mentioned it to the court, but it's the same allegations. It's the same stage of the proceedings. It's a probable cause finding or not. The district court judge who assigned the $5 million was privy to a certain amount of information, again, but this time fed to them through HPD, the whatever lead detective, also the JDPC, the judicial determination of probable cause, which needs to be filed to hold someone past that 48 hours in support of the charge so you can get to that preliminary hearing stage, again, a preliminary hearing that the government never intended to proceed with. Why? Because why have holes poked in their case at such an early stage? We've already seen from the trajectory of the case that we have the complaining witness or alleged victim in this matter filing a TRO not long after the incident, only to later withdraw it once no bail was set on May 13th by Judge Wong of the First Circuit in the circuit court level. So again, sort of a long-winded answer.
Keeping in mind that the TROs had a number of salacious facts that have not to date been proven accurate, such as the syringe, and he tried to stab me with it, or he tried to fill it in again and to attempt a second effort to inject her or something. Nothing was ever recovered associated with that. But it's salacious enough and it's alarming enough that it's featured, in any consideration by the court. It looms large in the public mind. It looms large with the court. That he is using his skill set, his knowledge as a doctor. I mean, all these things are highly inflammatory and most likely not admissible in any kind of proceeding where the rules of evidence are applicable. But in front of a grand jury, hence the notion that you can indict a ham sandwich, which is really true. And it's really rare that defense counsel has an opportunity to present anything. In fact, the last time I think that happened was when a police officer was accused of felony abuse with his girlfriend, and it was caught on camera, and the prosecutor's office very willingly allowed Howard Luke to bring his client, the victim in the case, to tell the grand jurors, oh no, we were just playing around. I do jujitsu, he does jujitsu. We like to do these things in public and fight with each other. It's all a big yuck. That was convenient because then they got a no bill. But that's when the prosecutors are working hand in glove with the defense counsel to protect someone in law enforcement.
And Nicholas, if you may, just one final thought to tie everything back together. Under Chapter 804, which governs the rules pertaining to bail, a bail hearing must be conducted before bail, that right, is taken away from an individual. Well, at that grand jury bail return hearing, that's not a meaningful hearing. Again, it's ex parte. There's no one advocating for the defense. It's just the prosecution, as Myles said earlier, trying to keep people in custody for their own prosecutorial pursuits. And we can all agree that domestic violence is bad and that attempting to murder someone is bad. But we don't have those facts in this case, as noted by Tommy Otake at the bail hearing. At most, it was assault 2 facts, C-level felon. And yet Judge Wong denied the request for $100,000 to $200,000 bail, knowing full well that with the divorce proceeding in parallel, there was that restraining order on the assets, and that Mr. Koenig was not a flight risk. He was not a danger to the community, because we can all agree as well that we want to protect the community from the people out there who truly are a danger to the community.
Yeah. So,
Even those individuals are entitled to due process rights and the
mm,
protection of our statutes and our constitution. So thank
yeah,
you for that loop together.
I wanted to like bring up how easily bail could have just been set at 100 to $200,000, just like how Mr. Otake had recommended, and how that amount of money, I know as a bail agent, and I've done this over my 20-year career, we will search the globe and find anybody right around $50,000 will get me to drop everything because we have to pay the money to the court if we can't find him within 30 days. So I have a history where I've found people in the Philippines, I've found people in South America, you know what I mean? I found a guy in Morocco one time. And it's crazy to think that the amount of the bail, 100 to $200,000 in the eyes of a professional who has to guarantee that they appear in court, we're going to search the globe to find somebody if they do leave. And for whatever reason, it was conveniently left out that, oh, wait, she's on Maui, he's on Oahu. How about some sort of conditions, right? House
Well,
arrest,
it's no
electronic
different
monitoring,
than,
all that, right?
I agree with you, but it's no different than the same circumstances arise in federal court, and they'll have the person with a location monitor, whether it's
Hmm.
a wrist or ankle bracelet. The bottom line is that person can be tracked, and they can
Hmm.
easily do the same thing here. And then if they want to make sure that the state doesn't, if they can't afford it because the coffer is empty, they make the defendant pay for the device. Certainly, Mr. Koenig would most likely have been able to afford that. And that, again, she's on Maui, he's over here, he can't leave. There are a number of conditions that can be put in place for any defendant. It requires, daily check-in with the Office of Intake Service, check-in with their attorney, a variety of things. So there's really no reason to hobble someone other than to give them an unfair advantage at time of trial. As I said, the longer someone's in custody, the more likely that they're not going to try the case. They're going to work out a deal. And that deal is usually not to the benefit of the defendant.
I
Yeah.
mean, Nicholas, if you ever go to the sheriff's department on the first floor of the district court on a day with a custody calendar, it'll just break your heart the number of individuals who are willing to give up their rights and plead out just to be released that day.
Mm,
So I'll
yeah.
just note that. And as far as the bail amounts at 100,000 to 200,000 that you referenced, well, under our 804-9 of the HRS wide right statutes, the bail amount can't be punitive. It cannot punish those who can't afford it, and it cannot reward those who can. And in this case, Mr.
I
Koenig's
mean,
being punished.
several years ago, I participated in a bail reform committee. And we met over a 1 year period once a month. Recommendations were made by two retired judges. Uh, Participants were from all the neighbor islands, prosecutor's office, defense counsel, the Association of Hawaii Association of Criminal Defense Lawyers that I was representing, everyone, all the stakeholders, so to speak.
Yeah. And me for
All
one hearing, I got to go. And then they said, get out of here. I was there
that's
for one hearing. Just one.
and the bottom line is the recommendations have not been put in place.
Mm,
It's still money talks. That's the bottom line. And it's an unfair system and it hobbles everyone. And as Andy pointed out, you see this at the district court level, people not being informed of the implications and the ramifications of taking a plea early on just to get out of court. It's especially so when you have, say, a case that is an assault. Let's say it's a petty assault, right? But you add the word sex, like sex assault in the fourth degree. And they're not told, it's not clear to them that they're going to have to register as a sex offender for the rest of their life. And the ramifications can't travel outside the continental United States other than to Hawaii, Puerto Rico, and Guam for the rest of your life.
And Nicholas, to your point about searching the world over in support of ensuring compliance with court orders and appearances at court hearings, you and I, we share a background in surety bonds. I primarily focused on contract surety. You're in the commercial surety world, but we can all agree that when it comes to a bail bond, you're underwriting for a 0% loss ratio. And that
yep.
under HRS 804-51, I believe, the bail forfeiture statute, a lot of times this, again, just turns into a poor tax where we're penalizing those who cannot afford, or where the state's just coming in to try to tax the bail companies for losing someone who maybe got away through no fault of your own. Because, like you said, you've searched the world over, you've brought these individuals back. And when that occurs, you just get slapped with what, $250 in court costs, and everything goes back to the status quo. But what I'm getting at is bail bonds, even as a prosecutor, I celebrated them because, as Mr. Briner mentioned, and as you are well aware, with conditions, people can be released back into society with the supervision and with that Damocles sword hanging over their head as far as this is what's going to happen if you flee. And we're all familiar with, the Dog the Bounty Hunter show as well. But the bottom line is we can guard against any danger to the community, any risk to anyone in the community, as well as any risk against fleeing the jurisdiction with those conditions. As Mr. Briner mentioned, location monitoring, mandatory check-ins, and it's not just keeping tabs. They're also recommending pro-social steps toward rehabilitation, even for the innocent individuals prior to ultimate disposition of the case. What am I getting at? Standard bail conditions also include you must obtain and maintain a job. You must pursue education, things of that nature. And these are all things we can agree with. So when someone is denied the opportunity to prove themselves with those conditions, well, what's the point? Why are we doing this? It's just there's no due process. It is offensive to the Constitution and to our statutes that provide this mechanism to allow people to be out in the community where they can most effectively prepare for their defense because they
Yeah.
are presumed until proven guilty.
And then I want to circle back before we move on. I want to point out just it's a rug pull. He could not have made a $5 million bail. And I wrote in my newsletter that whenever I go to hearings about bail, and then you have a prosecutor, and then you have a public defender, and then you have a judge, and I'm looking at everybody in that room, and I'm like, nobody in this room, the judge included, could qualify for a $1 million bail. And I wrote in my newsletter, I'm like, yeah, maybe on character you could qualify, maybe on capacity because you're an attorney or a judge, you know exactly what the contract is, but do you have the liquid assets to be able to pay 10% or $100,000? What, when you get arrested on a weekend after being apprehended? Do you own a piece of property with enough equity in it to cover the $1 million? Like, I doubt anybody, with the exception of like, longtime attorneys like Mr. Briner or like, personal injury attorneys who have had a whole career of being able to earn money, invest money, buy that home, put equity into it. Nobody could qualify for $1 million bail. And then to think that he could have posted a $5 million bail and then had the right taken away, something about that just doesn't sit right. And I wish the court and the prosecutor's office would change that because routinely they raise bails. It's a rug pull on people who are just trying to defend themselves. So
Well,
I just wanted to, yeah, end with
given that
that.
we're the most expensive place to live in the United States,
Hmm.
and most people in Hawaii do not have their mortgages paid off. The vast
Yeah.
majority of people, because of the environment here and the struggle that people have day to day, they carry multiple jobs. It's really rare to find a family that doesn't have several individuals that are pulling two or three jobs at the same time. And people are remortgaging constantly because the cost of living. So the notion that anyone other than a billionaire can afford a $5 million bail makes it rather laughable. And it's all designed with one thing in purpose, to get people convicted without having the opportunity to have a fair opportunity to fight the case.
Yeah. So I learned from the bail hearing. Now we'll transition to the actual bail hearing, which is very different than that ex parte what proceeding that you were talking about, Mr. Strand. So the difference between the grand jury is they could just say whatever. No defense is there to like counter and make a counter argument to anything. It's easy, and there's really nothing you could do. They could do whatever they want in a bail hearing. At least you have your attorney who could like rebut what the prosecutors are saying. So in that specific hearing, um, Mr. Otake talked about how when you file for divorce, so you could have a toxic relationship with your wife, you could be in custody, and she could file for divorce. and then that triggers like a freeze or a restraining order on your assets. So now you don't have access to your assets. That was something that I learned, but I wanted to maybe make this a teaching moment because there was a suspected affair that Miss Koenig had a few months earlier in December, which I guess was brewing all the way until this event at the hike several months later. So, what could men do if they're in a situation where they're married, they got a 4-year-old and a 2-year-old, they love this woman, she steps out, and what could you do to prep and be prepared just in case something goes down and now you're getting filed a divorce against and now you can't have any access to your assets?
It's an interesting question because you really can't prepare for it. You don't anticipate these things. I mean, it's an interesting narrative that the complainant in Dr. Gerhardt's case came up with, that he did this to me because I had an alleged affair. It creates a separate storyline that disables the defendant, unable to rebut it. And it plays well in the media. It plays well with the initial judge who has to decide on bail. And they carry that the rest of the case. You can't, it's kind of the scarlet letter that he faces, that supposedly he did this because of that. And we don't know, because he has a different story. And Mr. Otake is a very good attorney, and he knows what he's facing.
And Nicholas, to further that point, we celebrate all genders and all gender identities, and what we see across the board in these situations is the weaponization of the court system. In this case, it wasn't just the initial district court complaint that the prosecutors cut and that the judge assigned that $5 million bail to, again, with the prosecutors never having any intention on proceeding to a preliminary hearing, which would have been the next step. But we also have the TRO matter, which had since been withdrawn. And it's very curious because when you look at the judicial determination of probable cause, and what I'm getting at is this all comes back to credibility. When you line all these documents up, the allegations by the alleged victim in Dr. Koenig's case that she set forth in her TRO petition, when you set that up next to the judicial determination of probable cause, which was drafted by an HPD investigator, and then when you put that next to what the state argued at the bail hearing later, it's just rife with inconsistencies. And
Yeah. Three
because
different
you're
stories.
Mr. Otake,
Exactly.
he brought that front and center before Judge Wong at the bail hearing. This multitude of alleged acts that would cause the result of someone's ultimate demise was really distilled down to those three allegations. One, the rock, which was not supported anywhere in the discovery.
Given that, again, that she repeatedly stated the TRO, as well as a little bit different story with the charging of the case, that she was repeatedly smashed in the face and the head with a rock, with nothing reflected in the medical records. There were no skull fractures and so on. The second one was what? The syringe, the accusation that he had this, but this never appeared. Yes, they recovered when they did a search of his home and his office. Of course, he's the doctor, the anesthesiologist. He's going to have that. If he doesn't have that, that'd be unusual. So again, you end up in a situation where you've tainted the well so thoroughly that the public has this kind of radiating factors that whenever the case is mentioned, these things jump out, even though most likely at time of trial, I would suspect you were not going to hear anything about a syringe because it couldn't prove that, and it's going to have to be eliminated out.
And that third allegation about forcing her off the cliff, again, as argued at the bail hearing, the location of this incident where you have two witnesses showing up after the fact to catch the tail end, it's a very wide open area, nowhere near the sheer drop that was first brought up by the complaining witness in her TRO petition, and then later walked back when she withdrew her TRO. And when did she have that dissolved? Curiously, it was after she had secured that no bail. So she let that TRO, those false allegations, ride until after the bail hearing. And because she knew, and the prosecutors know, that that's going to come back to haunt them later as impeachment evidence that would shred her credibility, bye-bye TRO. But we're still left with the inconsistencies. She's talking about, oh, he was upset because I wouldn't take a selfie. But then she says in a filed pleading, which she filed under penalty of perjury, that they did wind up taking a selfie. And it's just really disappointing when you have these layers upon layers of inconsistencies, which is not unusual in a domestic violent situation. And we are not blaming any victims here. We are just citing to the objective facts that were before us in preparation for this
Yeah. So I I that's
interpretation.
such
I
yeah,
mean, I,
that's
I would flip the narrative the other way. I mean, he's being painted as the one that is the provocateur, that he lured her to the Pali Lookout, that all these things were planned on his side of the equation. You can easily flip it the other way, that she took advantage of an opportunity to accuse him of abuse while people were nearby to acknowledge and call 911 and so on. It's not unusual. You see these things all the time when there's dissension and dispute in a marriage, and there's a large amount of money at stake, given if there was a divorce.
And to circle back, Nicholas, to your initial point about the restraining order on assets,
Mhm.
it's win-win for this individual because she can go into the divorce court at any time with her attorneys and move for a pre-judgment decree to advance attorney's costs. So while Dr. Koenig's deprived of his assets to defend himself in his criminal matter, his wife in the divorce proceeding is free to tax that marital property pot to no end in furtherance of her pursuits, which we've seen now involve filing a false TRO that had to be withdrawn, lest it hurt the criminal case later. And don't even get me started about how overcharged this is. Attempted murder based on these facts, please. And
yeah.
Steve Baum knows this, and yet he
Yeah.
still chooses his deputy to overcharge.
Yeah. So there's 3 points of clarification, or a few. I'm not sure if there's three, but the media narrative is he wanted to take a selfie, she refused, and while they're near the cliff's edge, he tried to grab me and throw me off. But allegedly, and this is backed up by the JDPC, whatever physical like handling was away from the cliff's edge, and it was after that selfie situation. And in that area, that's where allegedly um she threw herself to the ground after being held by the shoulders, and then he like supposedly number two, as they say in the bail hearing, tried to get a syringe out and get a vial and then inject her. But I did a simple chat GPT search on all the different things that you have in a pack when it comes to the cap for the needle, the plunger, the stem, uh, two needles, a bag, a vial. There was no evidence of that. So that's a little sus. You know what I mean? And then the last part that I think makes it a legitimate assault, to what degree we'll have to see, and you guys could, I'll ask a question on this next. So the rock is kind of indisputable because they did recover the rock. The rock is supposed to be anywhere from 14, 16 to 18 ounces, about the size of a softball. It was described as a lava rock. The reason why I'm a little unsure of the damage caused by the rock is because she reports being hit in the head approximately 10 times. If you have a rock the size of a softball and you're a man and you hit a woman approximately 10 times, that's going to be major, major damage. And you can't really see if there's incredible scarring on the head, or if she's just covering it up as a way to say, hey, we're not going to let anybody see, maybe there's not as much damage. So when it comes to the varying degrees of damage, what do you suspect that we're going to learn from whatever pictures there are from the head, and what degree of the assault is it? And where does
We're going to
assault
learn. I
go
suspect we're going to learn
to
that
murder?
I suspect we're going to learn she inflated the injuries, that they're
Okay.
inconsistent with the actual reports. And given what she said, it's reflected in the TRO, is also reflected in the JDPC, that she was hit repeatedly with a large rock. Well, there was no skull fractures reported. There was no avulsions to the skin. She received no sutures. If anything, she had rough abrasions. Does that amount to an assault one? Does it
No
amount to assault?
concussion. No concussion.
So you don't have any of the corroborating evidence that you normally would see with someone who's an attempted murder, or someone's being hit in the head, with a blunt force object, and charge it as murder or attempted murder? I doubt that. And I think Mr. Otake is going to have a field day when it comes to getting this in front of a jury, should it come to that, on what a false narrative was being fostered on the public by the prosecutor's office with the assistance of the complainant.
And Nicholas, to just mention one brief note, Mr. Otake did concede at the bail hearing that there was a laceration of sorts, and the source material for that diagnosis would have been an HPD Form 13, which is a physician's report, pretty standard paperwork that's filled out by the doctor who treats the alleged victim in relation to the crime. But in the fullness of time, we hope, I guess we'll learn more in terms of whatever other medical treatment she received, medical records. But to your point earlier, yes, it all goes back to relevant attributes. And in this case, when you have an individual allegedly striking another individual with a 16 to 18 ounce object, causing the blunt force that Mr. Briner referenced, you're going to see a lot more damage, regardless of gender, age. I mean, 10 times with a rock to the face.
Yeah.
But it all will be up to what the medical reports show in the fullness of time. And we just don't have that information right now. But just real quick, we've been discussing the TRO allegations. We've been discussing the judicial determination of probable cause allegations. We haven't touched on yet the fact that the state, in support of opposing Mr. Otake's request for bail to be set, attached in its notice of intent a copy of the search warrant that they pursued in this case. So we have three narratives now, this evolution of the story. And those search warrants, typically speaking, are either drafted in whole or in part by the prosecutor's office. They won't let the detective go before the district court judge to have the warrant signed off on until they've passed muster. And I've had cases in the past where a detective may have gone rogue and just submitted a warrant without anyone approving it from the prosecutor's office. Well, those cases, they don't get charged. So you can be certain that whatever prosecutor was involved in the search warrant at this stage massaged the facts a little bit more, aided that evolution of, okay, how do we present the best narrative for the grand jury later? So now we have the TRO allegations, we have whatever was said at the scene, we have whatever was documented in the JDPC, we have whatever was edited in the search warrant affidavit, we now have a grand jury transcript. So the inconsistencies are just going to grow over time, each time you bring this alleged victim into court. And we see that a lot with all of our cases. Every time they open their mouth, it's a different story. It's unfortunate for the interest of justice and for due process again, because
Is that the
everyone is on
strategy?
the same page as far as just telling the truth and allowing the objective facts to speak for themselves without any outside influence, taint, or bolstering.
Is that the strategy? So, as Mr. Otake noted in the bail hearing, when they go to trial and they intend to go to trial, this is a he said, she said type of case. So,
Exactly.
what are the typical defense maneuvers when you're dealing specifically with a he said, she said style case?
Andy?
The whole point is a search for the truth. We don't want to put innocent people away. We don't want to let guilty people free. As a community, we can all agree on that. But even individuals who are guilty deserve to have their fair shake at a fair trial. And when you have a situation where an individual is hell-bent on obfuscating the truth, adding to the truth, changing the truth, well, that's just not justice. So to answer your question, well, you try to expose those inconsistencies. You try to impeach their credibility. You're not attacking them. You're just trying to reveal to the world that just because he said something or she said something, we need to verify that. The first thing you learn in law school is trust but verify, essentially, when it comes to these types of allegations. You don't just take someone's word on blind faith. You don't just say, oh, the police officer wrote a report, so I'm going to believe what's in there. You go watch the body camera footage to see, oh, are we living the same reality right now? Is the body cam support what's in the report? Or you compare, as we said, those evolving narratives. What the TRO says differs from what she told the police in the JDPC, which differs potentially from what was presented to the grand jury. So you have to map those out. But again, it is a little bit tricky in the domestic violence area because under our case law and our rules of evidence, sometimes the prosecutors, they want that inconsistent statement because it's a timing game in terms of introducing prior inconsistent statements under our rules of evidence or prior consistent statements. So they can just cherry pick whatever narrative suits their mandate, which is to secure convictions at all costs. And we just saw that in State v. Cardona, a recent murder case that we received a 5-0 unanimous Supreme Court decision overturning that conviction for prosecutorial misconduct at the trial stage, and where we're now up before the Intermediate Court of Appeals, litigating what happened before the grand jury to see if there was any overreach there in violation of our client's rights. So to your point about what the defense can do, well, it's what anyone can do. You just have to search for that truth, find the evidence that supports the objective facts, take any spin out of it, so that when you ultimately go before the finder of fact or whoever's going to conclude on the law, you can present the whole narrative. It's not just this side, it's not just that side, it's here's the evidence in support either way. But you need to substantiate those facts, you need to corroborate those facts.
We've no doubt there's exculpatory evidence that Mr. Otake is going to uncover. The question is it clearly exculpatory? And I suspect Mr. Otake is going to discover that there was clearly exculpatory evidence available that the prosecution was aware of at the time they went to grand jury. It did not disclose that. And that is one of the most common errors that we see, that they're in possession of what they consider only exculpatory versus the normal legal standard clearly exculpatory. So we see this all the time. We also see frequent misrepresentations of the evidence, such as claiming that there are bite marks. We have a case right now involving child abuse. You can't testify because that is junk science. But we have a prosecutor who repeatedly stated to the grand jury that there were bite marks on the child's body. So again, there's very problematic. Or opining that there was a particular attempted homicide when the medical examiner can't say that. They can only describe medically what they discovered, and not the ultimate opinion is up to the jury, grand jury, or an actual jury trial is to determine.
So, but for example, if a medical examiner is going to opine on a type of cause of death, well, what are they actually qualified as an expert to testify to? And what does our case law support?
Or in this particular case, is attempted murder. Are they going to produce a doctor to say the injuries that she sustained amounted to life-threatening injuries? No. And the minor laceration you received did not require any kind of sutures. So again, the question arises, what in fact occurred there? And I suspect at the end of the day, a jury is not going to convict the doctor of attempted murder. We're looking at a significantly less serious charge, if not an acquittal.
So here's something that I did a little, citizen investigation. So I have a friend on the mainland that I went to college with, and he's an anesthesiologist. So he was able to break down the drugs that they listed at the bail, the motion to set bail hearing.
And they mentioned the same type of drug that was involved in the Michael Jackson case.
Yeah, propofol. So that had a chilling effect. And they had a specific section where they talked about, and they took a break, and Judge Wong asked, are these controlled substances? Like, are they on the DEA list where, you're not allowed to have them? One, they're not on the DEA list. He's allowed to have them. I gave the list to my buddy on the mainland, and he was like, "Oh yeah, that's for like pain," and he's like, "I've used all of those this morning alone. Those are normal drugs." The key thing that I want to point out, and you attorneys could tell me how this could help Mr. Koenig, Dr. Koenig, is those drugs listed in the report were all the type of drugs where they're ineffective if you just put it into a vial and then stick somebody with it. Right. They're all the type of drugs that need to be put up with an IV and then put in intravenously. So it's not like he had access to any of the drugs that you could just puncture somebody and then they go out or die or something. This is like they're
circle back to what I said earlier about flipping this narrative. This narrative is being generated by the complainant in the case against Dr. Koenig. And they made a mistake because the particular drugs they're talking about, if you inject the person, they're not going to drop dead. They're not going to
Yeah.
fall to the ground unconscious. It requires an open vein intravenous introduction of that medication and titrating in a certain way. So anything short of that, it creates a narrative that's actually in Mr. Otake's favor for his client, that she came up with something that's completely fallacious, that she should have known better, but that was her story.
And if you
And
look at the state's notice of intent
mhm.
in opposition to the bail hearing, request for bail to be set, if you look at the affidavit in search of the search warrant, which is a publicly filed document, at the end of the day, this is all happening after the fact. A Nike brand black colored fanny pack, et cetera, recovered by the Maui Police Department from Ariel Koenig in connection with this matter was mailed via FedEx to HPD. So where's the chain of custody?
Yeah.
Who's the gatekeeper as far as the veracity of this evidence? That's really troubling for the interests of justice.
So in other words, in support of her TRO, in support of her claim that she's the victim of an attempted murder, she arguably, she put together a little pack of drugs that would implicate her husband. So it's rather convenient.
I can't believe I missed that. Like
If a
I knew,
prosecutor reviewed this, a
uh,
detective signed off on it, and they bamboozled a district court judge into believing that this is legitimate objective evidence without any further verification. Is
I
how
was
I
just, yeah, I was just thinking, hey, that's kind of funny. Were the drugs found at the hotel? Were the drugs found like, on the trail? No, no. They just happened to apparently be found at the home in Maui, but now we don't even know that because she somehow got these drugs and submitted it to MPD.
If they found it at the home in Maui, he's already
Okay.
under arrest. They have an attenuation problem and a chain of custody problem, a number of other issues that in violation of Dr. Koenig's Fourth Amendment rights.
where's the indicia of reliability? Oh, they put some Maui Police Department evidence tape on it after the fact before shipping it back to Oahu. Okay. Miss Dr. Koenig's in custody at that time.
Yeah, I have
And
my
there's
questions
enough
on that
problems
level
over at the
too.
Maui Police Department. We're representing right now a woman who was sexually assaulted by a police officer who left his handcuffs as a gift following a sexual assault.
Hmm. So the next thing I want to, well, I'll close the loop on that by saying, dude, there's a lot of problems with these supposed drugs. One, they're ineffective unless given via IV, so they weren't dangerous. They weren't on the DEA exemption list. So as an anesthesiologist, he's totally welcome to have whatever it was, and he might be like a prepper where he's thinking, man, just in case of an emergency and I need to help somebody, why not have these things? And
Let,
then
let me ask
last,
you, let me ask you something. I'm sorry to interrupt you. I come from a family of physicians. You have friends that are physicians.
yes.
Most doctors have kits like that all the time.
Yeah.
They keep them around the home. They keep them in their car. They keep them at work. Um, I grew up in Michigan. We have, there's a wood rattler that's poisonous in upper Michigan. Okay. My father carried, wherever we went hiking, anti-venom injections just in case.
Hmm.
So does that make that my father, suspect that he would carry those with him? No, he's a doctor. So I
Yeah.
would submit that would not be unusual that Dr. Koenig would have that fanny pack. But again, as Andrew pointed out, we don't know who put that fanny pack together.
Exactly. Chain of
You know,
custody's all messed
uh,
up.
it's so convenient that, oh, by the way, this is what I found in Maui. Well, I thought the assault happened over here on the Pali at the Pali Lookout. So why would that be involved in the case whatsoever? But it looks good when you go in front of a judge and ask for a no bail.
Yeah. So, uh, I did think there's a number of vindictive things. Maybe I'm just jaded and I don't trust women. Maybe, in fact, I'll just say that I don't trust nobody. I couldn't help but notice in the TRO, Dr. Koenig has a son from another marriage,
Correct.
and Ariel and Dr. Koenig got married in 2018. So it's been about 6 or 7 years. So she's barely a stepmother. I mean, I'm sure they have a great relationship, but it's not like she was there from the early years. It's like he's a 19-year-old kid now, and what, it's been a few years as a teenager. It's very difficult to assume that, oh, now I'm your mom. That's a very loaded thing. So he was included in the TRO as well as the dog. So I couldn't help but think that was vindictive. So is it common to put a stepchild, even a dog, into a TRO? Is that
It's hard
necessary?
to say. It's hard to say. I mean, we're speculating about the nature of their relationship, but it is a poke in the eye to Dr. Koenig that they would do that involving his son from another marriage and a dog. But it's the nature of relationships, okay? That's these
Huh.
things.
It's also a type of bolstering.
Mhm.
When you think about it, if you're the judge reviewing that
He's
petition, the
he's
more the
so
merrier.
right. He's so dangerous. He's a danger to his dog and to
Yeah.
his.
And that's an old prosecutor trick as far as alleging a nexus between animal abuse and people abuse. They'll
Hmm.
cite the FBI studies suggesting
Right.
that someone who beats their dog has a higher propensity for beating humans or assaulting women or what have you. And then when we as the defense try to point that out in court to argue against the credibility or the primary aggressor issues where we have an alleged victim that the state's trying to convict our guys of, where this alleged victim beats animals, destroys parrots, what have you, maims dogs. Well, then all of a sudden it's, oh, that's not reliable. FBI can't be trusted. Forget about that study, inadmissible. So it really is a one-way street sometimes when it comes to these arguments. When again, we're on an island. This is our community. We're all looking out for one another. So it has to be fair and it has to be a level playing field. And we're just not experiencing that right now under the current administration over at 1060 Richards. It's conviction at all cost. They're not verifying their allegations. They're proceeding on unsubstantiated, uncorroborated evidence most times. And they're just turning a blind eye. It's willful blindness to the fact that, oh, the TRO, look at the timing of it. Only filed to bolster the bail argument, and whether it was withdrawn out of remorse because Ariel knows that she made false statements therein, or whether it was because of a strategic reason to avoid having that additional impeachment evidence at trial. We don't know. But in the fullness of time, we'll find out who's telling the truth in this matter or not. Because there's always half truths and half lies. But the prosecutors will go full bore and say, nope, that's what happened. That's our narrative. That's what we're sticking with. And they will never back down because that's their arrogance.
Yeah.
They can never admit that they're wrong.
And then they had the benefit of the right judge from the prosecutor's perspective.
They'll believe any accusation as long as it tailors their agenda or aligns with their agenda rather. And that's just abhorrent when it comes to, again, due process rights and ensuring that every defendant gets a fair shake, gets a fair trial, gets equal access to justice.
So what would be like, you play chess, Mr. Strand.
I'm a
What would
horrible
be
chess player, by the way, but thank you. I do prefer checkers.
yeah. So in playing
My children repeatedly beat me at chess, but I do play chess.
yeah, well, legal chess, because I know there's traps that in a trial you set up to make appealable sort of opportunities for appeals. So I have a two-part question. One, how come it takes like 2 or 3 years before you could actually get an appeal filed and before the appellate court? And then secondly, what would be some of the tactics that you guys would sort of set up as traps during this first trial to give yourself more purchase or ammunition for
Oh,
a future appeal, just in case this guy continues to get railroaded? Because obviously he's being railroaded as we speak. He's got no bail and he's just languishing in custody.
I don't want to speculate. I think Andy has some thoughts on this matter, but
Hmm.
it's a little difficult to say setting something up. I mean, frankly, the prosecutors more often than not shoot themselves in the foot and give us the opportunity to exploit their mistakes.
Hmm.
There's an overzealous attitude. There is a win at all costs. There's an attitude that the means are justified, or the ends are justified by the means, I should say. So essentially, we've prevailed, for example, on this recent appeal in the Cardona case, um, not by setting anything up. We allowed the prosecutor to express and conduct himself in such a way that he thought he could get a conviction with impunity. The judge that heard the case had not done a homicide case before. the public defender on the case had never tried a case against this formerly retired prosecutor who had been brought back specifically to homicides for the prosecutor's office. And he managed to demonstrate why he shouldn't be doing this. I think Mr. Strand identified 18 separate misconducts by the prosecutor in that murder case. The Supreme Court, when he argued the case, we were convinced that the Supreme Court, at least on a 3-2 vote, would rule in our favor. Much to our joy, it was a unanimous opinion that even conservative judges that just come onto the bench realized that the prosecutors were overreaching, they're overzealous, and they violated the most fundamental tenets of allowing the defense, an opportunity to rebut the charges free of all the innuendo and outrageous statements undermining the defendant's ability to get a fair trial.
So why the big delay in the court system in being able to get an appeal heard?
It's really, Andy?
Well, as far as having it heard, within 30 days of the judgment, you can file your notice of appeal. Then it's just a matter of the record. And that's what I want to make a point about. It's all about protecting the record. And as a defense attorney, I don't know that we're ever trying to set up any traps. We're just zealously advocating for our client. We're going after that NG verdict because we're trying to expose all the flaws in the state's case. We're trying to present that objective truth on behalf of our clients and to present the fullest possible defense.
I mean, our particular practice is a motions practice. We file everything possible in all of our cases.
Yep.
And
I know. I review those motions.
Things up so the notion of setting it up, well, frankly, the prosecutors set themselves up. We can't file these motions unless, of course, we see all these egregious mistakes, some intentional, some due to incompetence or lack of training. But more often than not, we can't create these problems. We exploit them and we go at them, vigorously. The result is that we, in most of our cases, are prevailing. We either prevail at the appellate level. We right now we have at least probably 2 or 3 cases that are up on appeal. We have one that we're proceeding on interlocutory appeal, and that says a lot. We have our judges generally don't grant discretionary motions to proceed with an interlocutory appeal in the middle of a case, unless the issue involved is dispositive, could be determinative of what the case would do going forward. And we're very happy we're able to do this, but we can't do this unless there's a basis for it. And it's nothing that we can set up, we can identify. And that's really where it comes down to, that defense counsel needs to be able to identify these things to exploit them. And fortunately for Dr. Koenig, Tommy Otake knows exactly what he's doing.
Yep.
I doubt they're prepared for dealing with Tommy. Tommy knows what he needs to do for Dr. Koenig. Yes, it's difficult when your client's being held in custody because you have a much easier time pursuing the case when your client's free to talk to you about the case throughout the trial as discovery is disclosed. So yes, that's a problem. But I suspect at some point, Tommy's going to win Dr. Koenig's release or come up with other alternatives for bail, such as electronic monitor and so on. Or he may have to proceed to recuse the judges hearing the case. It depends. I don't know. The selection of judges on these serious cases raises questions all the time with defense counsel. Like, why are this particular judge is getting these particular cases? It isn't random, in my opinion. Often it feels and appears that these particular judges are going to get these cases because the prosecutors are assured they will not reduce bail and they'll keep them locked up.
And Nicholas, just to continue off of that and to get back to why it takes so long to get vindication at the appellate level, it goes back to the record. And as a prosecutor, you are supposed to protect the record. It's also the judge's job, but you need to make sure, and when I say the record, we're talking about what's said in court, what's filed in pleadings, everything that goes up on appeal for the appellate courts to review. You can ask William Hoke or Walter Rodby. I've had cases with them where they've taken me up on appeal in the past. And in that capacity as a prosecutor, I've prevailed because I protected the record. State v. Singh was a best evidence rule issued before Judge Trader. State v. Kaleke out in Waianae District Court before Judge Nishimura. But the record is key. And so it's not about setting traps. Maybe if you see a prosecutor committing misconduct mid-trial or mid-hearing as a defense attorney, if you're not going to win that day by calling it out, you just let it ride for the appeal. Because once it's in the record, it can get before the appellate court, but that record takes time to develop and it takes time to prepare and package for the appeal. So you say 1 to 2 years. Well, yes, it does take some time because you file your notice of appeal, then you request your transcripts, then you wait for the appellate clerk to gather the record on appeal, then your appeal can be duly docketed. You'll get your deadlines for your opening brief. Generally speaking, the state asks for 1 or 2 extensions. I don't know why. Maybe it's volume. Maybe they just don't care because why expedite a review of our conviction,
Yeah.
etc.
Well, one of the big problems we're having is we don't have enough qualified court reporters, and the court reporters are overwhelmed. They're having to produce daily court transcripts when they're major murder cases, attempted murder cases, sex assault cases. Counsel, both defense, prosecution want daily transcripts very often. And then separately, the issue of having the record prepared so that it can go up on appeal, you got to get those transcripts together. So right now we're looking at roughly a 6-month waiting period, which it doesn't help the defense in the least bit. The person's waiting to get the appeal done or do the interlocutory. So it's a problem. So the extension 1, 2, 3 years is not unusual. We're experiencing 5 and 6 year delays.
And Nicholas, you can reflect on your own practice. Just walking around the courthouse 5, 10 years ago, every courtroom had a court reporter for every proceeding, especially trials. Now they're so heavily reliant upon the for the record audio recording system that this insurmountable backlog of transcripts that need to be prepared. And you can't go up on appeal until you have those transcripts, which is a written transcription of whatever courtroom audio occurred. And Myles is right. At least 6 months or more sometimes if you're trying to pursue a pretrial motion. Sometimes it's a little bit quicker for the grand jury motions, but on appeal, a little bit faster, but still you are getting those delays. So if we could get more funding for more court reporters, that might expedite the process. Because at the end of the day, you have a convicted individual who's pursuing a meritorious appeal sitting in custody because the paperwork can't be generated. I don't see the justice in that.
One of the things that we've done in our practice is we use there's an app called AutoScribe. Is that correct?
And there's other available alternatives in terms of TurboScribe or Drag and Dictate or what have you, but those aren't official records. You need an officially trained court reporter to sign off on it, and that's statutory as far as the Hawaii Revised Statute is concerned. But it's not like you can create your own record. No, the judiciary is the gatekeeper, and they're doing the best job they can, but they just don't have the resources right now. And so if that's something the ledge can throw some money at, that would help defendants across the board. And the fact that it hasn't happened suggests to me that maybe there is no constituency out there to protect defendants' rights.
Well, shout out to the ACLU. This is an easy win, and it's a budgetary concern, and it could easily be thrown a budget. It could easily be petitioned for, and with AI, most of the work could be done and then just reviewed by a court reporter. They shouldn't actually be doing the work. Easy to transcribe an audio recording nowadays. So hopefully,
it's been a pleasure talking to you. We need to get to work.
All right. So, thank you very much for your time. Hopefully we could have another conversation later as this trial unfolds. Can I ask one more question before you leave? Last question, because this is an internet question. I do believe Dr. Koenig, based on the allegations, probably did have a mental breakdown. He probably was dealing with a toxic relationship for months on end, maybe even years. It is in the report that they'd been going through marriage counseling and stuff. He had an episode. It's okay. I lose it sometimes. I don't push people down and hit them with a rock, but hey, I lose it sometimes and I'm short with people. It happens. So is there like a temporary insanity defense or anything along those lines that you see? Last question.
Interesting question.
I think we'll leave that to Mr. Otake. We
Yes.
want to stay in our lane and not interfere with his defense. We're just not qualified to answer that right now, given the information we have.
There's a lot of aloha for Tommy Otake, and I don't want to say something that would in any way impinge upon his representation. There are lots of things that can be done. Tommy's a very smart guy and he knows what to do. So I would tell the prosecutors, you're in for a ride.
Buckle up, pack a lunch, right?
There
You
you
got
go.
Mr. Otake on you. Okay, well, thank you very much for your time. Hope to talk to you guys soon again. Thank you.
Aloha.